Happy Friday. I get asked all the time for an update on the creepy cop search case out of Putnam County, West Virginia, where plainclothed police officers from the Sheriff's Department's Special Enforcement Unit were caught on hidden camera literally breaking into my client's home, sneaking in through the window, searching the inside of his house for non-existent drugs. To see footage of police officers secretly inside someone's home where there's no criminal investigation, much less criminal charges, it's just scary, especially where there's no legal justification for them to be there. So this was actually my first YouTube video, uploaded January 15th, 2020. And the footage shows Drug Task Force officers searching Dustin Ellswick's house, including examining the ashes of his deceased friend, brilliantly believing them to be drugs. They also ran those ashes through field drug test kits, disabled an exterior surveillance camera, pulled Dustin's guns out of storage for photographs, and generally ransacked and searched the place. Take a look at the footage. Until I uploaded the video 2.5 years ago, they had no idea that they had been caught on video. I first provided the video to federal prosecutors, who in turn provided it to the FBI to investigate. I didn't know this at the time, but the FBI agent tasked with the investigation didn't investigate, but rather just tipped off the officers that I had a video showing them in Dustin's house. I only found this out much later, after the lawsuit was filed and discovery was exchanged. Federal lawsuit was filed in this case on August 20th, 2021 against the individual officers as well as against the county for the pattern and practice claim. The federal court did deny the county's motion to dismiss that claim, issuing a memorandum opinion explaining the basis of liability against the county here. So right now, this case is set for jury trial, federal court in Huntington, West Virginia on February 22nd, 2023. There were also 2 companion cases filed on behalf of other plaintiffs, the Johnson family as well as the Mason Dillon. Those are currently pending also and set for trial. However, this is the only case out of those 3 that was actually caught on video. The Dillon case is set for trial on January 18th, 2023. The Johnson case is set for trial on January 31st, 2023. As of right now, these cases have not been consolidated with the Ellswick case. They are proceeding separately. So discovery has been exchanged in this case, so we know a lot more now. However, depositions have not yet occurred, having been delayed several times due to the defendant's concerns over a renewed FBI investigation, following the disclosure that the initial FBI investigation really was more of a locker room pat on the butt than an investigation. I suspect that the current investigation could actually be an investigation of the first investigation, but I really have no idea as of right now. What I do know is that finally we're set to take the depositions under oath of these police officers at the end of this month. And it will be interesting to find out whether or not they will plead the Fifth Amendment. I honestly hope that they don't. Either way, I already have their statements from the still confidential internal investigation that occurred after the video was released. This is the county's investigation. So if they don't want to answer questions at this point, there are mechanisms in place for me to utilize their prior statements. What I can tell you is that really there is no good explanation here at all. There are some excuses and some finger pointing, but there's no good defense here. I believe that it will be determined that some of these officers are probably more culpable than others, which is why I hope that at least some of those officers are willing to tell the story. So it's interesting what happened in that it resulted in the end of the Special Enforcement Unit, but it didn't result in the end of these officers' employment with this agency. There is more to the story that's not out yet. Now, remember, generally speaking, on the law, your home is your castle. It's the most protected place that there is under the Fourth Amendment. Any search or seizure by the government that takes place in the home is automatically unconstitutional by default, unless the government can prove otherwise in the form of a valid warrant or a valid exception to the warrant requirement. And there are only 2 exceptions recognized by the U.S. Supreme Court: consent and exigent circumstances. Consent must be voluntary. Exigent circumstances require something akin to an emergency situation. And again, that's on the government to prove. Also, when it comes to consent, as I've explained previously in context with this case, a landlord cannot authorize the government to search a residence of a tenant, as per the U.S. Supreme Court in the 1961 case of Chapman versus United States. So this extends to apartments, rented rooms within a house, and hotel rooms, so that a landlord may not give consent to police to perform a warrantless search of a rented apartment or room. Lastly, these cases tend to speed up towards the very end of litigation, which is where we are now. So there will likely be a big update or updates very soon. We have a mediation scheduled next month in August, which is an opportunity for both sides to sit down with a mediator and discuss potential settlement resolutions. In this case, this is a civil lawsuit, a civil rights civil lawsuit. So the potential remedy available to us is money. So that's always the case in these in these cases is we can't get people fired. We can't put them in prison. The remedy available to us by Congress is an award of money damages. So that's where money will be discussed for the most part. And if that falls through, we'll just sort it out at trial.